Grant Robertson.
Thank you very much, Mr Chair. And as you indicated yourself in your ruling earlier on, this title and commencement debate is an opportunity for members of the House to bring together some of the threads of discussion. And I'm deeply disappointed Mr McKelvey had made a great start the other evening when we were debating this bill, didn't share his wisdom with us any further on the question of why he supports why he supports. Well, in the case of Mr McKelvey, that's definitely true because they often aren't given. But why he actually does support this legislation, because we haven't really heard anything about that from the government members about why they actually support this legislation. They haven't answered the questions that have been raised on this side of the House, legitimate questions around the extent of the powers granted under this bill, around the additional costs that have been placed on business, around the potential stifling of innovation that will be caused by this legislation. None of that has merited a response from the National Party's side of the House. But to entertain Mr Finlayson, I will speak on both the title and commencement clauses of the bill. And it is interesting. It is interesting. I'm here for your benefit, Mr Finlayson. It is interesting when we do look at the title of the bill, the Telecommunications Interception Capability and Security Bill, that the addition in terms of the legislation that is repealed by this Act is the addition of the word security. So we have had legislation called the Telecommunications Interception Capability Bill before. What the government is doing here is introducing the notion of security. And as has been stated several times during this debate, there is a balance to be had between the rights and freedoms of New Zealanders, in this case to communicate with one another via a variety of technologies, and the security of New Zealand. Nobody on this side of the House is denying the fact that we need legislation that upholds that balance. But the problem we have is that this bill, alongside the other piece of security legislation that goes with it, the GCSB bill, unbalances that equation. The fact is that the fundamental rights and freedoms that New Zealanders expect to have been undermined. And the introduction here in the title of the word security is there, designed to make New Zealanders feel that the government has brought forward legislation that will enhance their lives, that will ensure that they will be safer. But in reality, Mr Chair, that is not what this legislation will do, or certainly the case for that has not been made. And Mr Chair, it's what then that leads me to the amendments to Clause 2 proposed by Claire Curran on SOP 370. And the first of those relates directly to the fact that this is now not only about the ability to intercept communications and why that might be required, but it is now fundamentally part of New Zealand's security framework. A security framework that is governed and controlled in New Zealand by legislation that we on this House believe to be wrong, and also by agencies that are in turmoil. And that is the effect of the amendment to Clause 2 that Claire Curran is proposing. And that is that this bill only comes into force once there has been an independent review of New Zealand's security agencies, and those recommendations from that review are incorporated into any bill that is put forward for a third reading in this House. This needs to happen, Mr Chair, because the GCSB, who play a critical role in this legislation, they are the agency who are responsible for large tracts of the implementation of this legislation. They are an agency whose name has been muddied over the last couple of years and in whom New Zealanders have quite simply lost confidence, Mr Chair. The independent review that is being called for here will enable New Zealanders to understand the role the GCSB can play in a changing world. And there is no doubt that in a changing world of cyber security is important. So it's not a denial that that is a role that the GCSB should have. But given the state of play with the GCSB, the fact that they've been discredited, the fact there's been so much lack of clarity around the law that governs their work, this amendment from Claire Curran is undoubtedly justified. Because unless we can rebuild New Zealanders' confidence in the GCSB, their role in implementing this legislation, I believe, Mr Chair, cannot be upheld. The Minister of GCSB, yes, well that would be the Prime Minister John Key. And when he stood in this House and told Mr Chair,
The Honourable Member Grant Roberts.
When he stood in this House during the GCSB bill debate and told New Zealanders that we just had to trust him on how aspects of the bill would be implemented. That's right, and 26% of New Zealanders somehow or other still trust him, but we just had to trust him on the way in which he would issue warrants. That's the moment, Mr Chair, at which New Zealanders must know that the role the GCSB plays has to be reviewed. It has to be reviewed alongside all other security agencies, and it has to be reviewed in light of the wider responsibilities that they are being asked to undertake under this piece of legislation. And that is why Claire Curran has proposed the amendment on SOP 370. The other amendment that Claire Curran has proposed to Clause 2 is the question around whether or not this bill should be reconsidered under the New Zealand Bill of Rights Act. And it would be useful if the Attorney-General might choose to take a call and justify to this House whether he believes that the vetting of this bill in terms of our Bill of Rights Act has been sufficient, because many other people do not believe that. The Attorney-General, who is very reluctant to praise himself, says that this was very well done. Well, the reality is that many other agencies don't believe that. And secondly, a lot has happened to this legislation as it has progressed through Select Committee. A substantive but not particularly relevant SOP has come forward from the government. That has not been tested under the Bill of Rights Act. And it is worthy of note, Mr Chair, that the Human Rights Commission exercised its statutory power to directly report to the Prime Minister on this piece of legislation and its companion legislation, the GCSB bill. That is a power they have rarely exercised in their existence, I think less than half a dozen times. So that indicates the level of importance the Human Rights Commission puts on the TICS bill. And they note that in their submission around the TICS bill, they are particularly concerned about the ability, and we discussed this in one of the earlier parts, the ability of those who end up caught up in the Act to be able to be in court when matters involving them are heard, or at least be represented in court, and they are concerned that this breaches the right to natural justice in section 27(1) of the New Zealand Bill of Rights Act. There's a specific concern for the Attorney-General to respond to as to whether or not this bill has had adequate vetting. The Human Rights Commission believe that the right to natural justice is compromised by the clauses in this bill that do not automatically allow defendants to be present when matters pertaining to them are in front of the court. I am not a lawyer. Mr Finlayson will be glad to hear that, I am sure. But what I know about the law is that you have a right to be present when matters pertaining to you are heard before a court, and you have a right to be represented. One has a right to be present when matters pertaining to that person are heard before the court, and that is a right to natural justice. That has not been upheld. That means that the SOP in the name of Claire Curran on 370 that says that this bill can only be submitted for royal assent if it has been reconsidered under the New Zealand Bill of Rights Act is totally justified in my view, Mr Chair, because the overall question around surveillance and human rights is one that is very much in the mind of New Zealanders and people around the world. Just today in France, the French government is calling in United States officials to ask them what has been going on in terms of mass surveillance. The question of surveillance and human rights is one of the most current questions of our time. And on this side of the House, we don't say that because we don't believe the state has the right to undertake these kinds of operations. It's actually because we want to protect the fact that the state may need to do that from time to time and balance that with the rights of New Zealanders to go about their business. And under this government, that balance has been lost. Trust in the agencies who undertake that work has been lost. That lies directly at the feet of the Prime Minister, who has evaded answering questions, direct questions about the role of the GCSB under his watch. The GCSB get extended powers under this bill, and New Zealanders have a right to know that that has been thoroughly checked against the Bill of Rights and that their basic rights and freedoms are being protected. And not once in this debate, Mr Chair, have members of the government got on their feet and said to this House, we believe the balance is right, because it's not.
Mr Chairman. The Honourable Member Stephen Brown.
Thank you, Mr Chair. Rise to